Okay, let's go on the record on DC 22-13323, Ramirez versus Provider Transport, LLC. Council, make your appearances.
Your Honor, I'm sorry, Moises, go ahead, man.
Yeah. Moises Morales for the plaintiff.
Danny Andrews for the defendant, Provider Transport, in place of attorney of record John Malanga.
I understand there's been no objection to hearing this remotely, correct?
Correct.
That's
Right.
correct.
We may proceed.
Thank you, Your Honor. Provider Transport, the defendant, is the movement in the hearing, Your Honor. This is a personal injury commercial vehicle case, and so it's a motion to bifurcate the trial under the new Texas Civil Practice and Remedies Code, Chapter 72, Section 052, where the defendant may ask the court to provide for a bifurcated trial where negligence and compensatory damages are tried in the first phase of the trial, and gross negligence and exemplary damages are tried in the second phase of the trial. And that's the motion that Mr. Malanga has filed requesting that bifurcation under the new statute.
Any objection? I didn't see a response.
No, Your Honor. It seems that everything was done properly by the defense in this case and for this motion.
Okay, the court, this is the first one I've had of these, actually, kind of surprisingly. Let me see. And did you provide an order on this?
Mr. Malanga sent me a proposed order, and I couldn't tell if it had been sent to
yeah, I see it.
The proposed order pretty much tracks this, based on my reading, pretty much tracks the statute, unless Moises has a opinion one way or the other on his end, but I think it pretty much tracks the statute.
It does.
Okay, let me just do this. I want to show you what I have here. I'm going to share a screen and just make sure this is the right order that you wanted me to sign. Is that the correct order you wanted me to sign?
Yes, Your Honor.
I haven't, dealt with this issue, to be honest. Is it a situation where we would try this and then have it two different juries, or?
No, Your Honor, this is that new statute that was passed last legislative session, went into effect September 21, and it's the reality of it is trying to make the plaintiff jump through as many hoops as Moises knows, through as many hoops as possible in trying the case. And mainly, my interpretation of it is it wouldn't be two separate juries. The jury, after the first phase of the trial, would mainly, the idea of the statute is to mainly try the driver under a negligence standard, and hopefully for the plaintiff, receive a liability finding in ordinary negligence plus compensatory damages. Jury would be sent out to make those findings. Then I think, and Moises may weigh in at any time, because I certainly have no pride of authorship in the statute, but then the jury would come back in, and then the second phase of the trial would be presented by Moises, and it would be possible. There's a lot of exceptions in the statute, as Moises knows, right, to where some negligence or breach of the Federal Motor Carrier Safety Standards may be brought into evidence in the first phase of the trial if you can establish proximate cause. The wording of the statute is if it tends to establish proximate cause. I imagine Moises is going to jump all over tends to establish as much as possible, which is what he's supposed to be doing. So a lot of the negligence to the employer can be tried in the first phase, I think. But the gist of it is, the jury goes out, comes back in for the second phase, which under the statute is supposed to be all about gross negligence and or gross negligence against the employer if there's violations of the Federal Motor Carrier Safety Standards, the DQ file, et cetera, et cetera, et cetera, and finding on exemplary damages would be in the second phase. I think it's the same jury that goes out after the first phase, makes the findings of ordinary negligence, comes back in, and I can't imagine seating two juries going through voir dire twice. I can't imagine doing. I don't think that's what the statute wants.
Okay.
Same jury comes back in, Your Honor. That's my 2 cents for what it's worth.
Yeah. Your Honor, same here. I think it creates a bifurcated trial with the negligence of the driver and actual damages in the first phase, along with some claims against the employer or the owner. And then the second phase is strictly for punitive damages against the owner or the employer, the company.
Okay, well, good. We signed the order, and it's not going to change anything, I guess, from a scheduling standpoint. Let me see when your trial setting is.
I don't know myself.
Let me see. It is. Make sure we have a trial setting. It is September 19th of 2023. So, just FYI, have you already been to mediation?
We're set for some time in early March, Your Honor.
Okay. All right. Well, good. Good luck, guys, and we'll see you on the next one. And
Okay.
I've already submitted the order to the clerk's office, so it should be available later today.
Thank you, Judge Hoffman. Moises, thank you. Nice to meet you, Moises.
Nice to meet you too. All right.
Okay.
All righty, let's go to the next one. Keisha Jones versus, okay, we've already dealt with that. So I think our next one is TNC Leasing versus O'Malley's Transportation. Anyone here in that case?
Yes, good morning, Your Honor. How are you?
Good.
This is Jacob Hamilton on behalf of O'Malley Transportation and Lindsay Cheatham. We are moving to withdraw today.
Is opposing counsel here?
Yes, Your Honor. Rebecca Brown for Plaintiff, TNC Leasing.
All right, let's Tony, let's go on the record on DC 21-14729, TNC Leasing versus O'Malley Transportation. Counsel, make your appearances.
This is Jacob Hamilton on behalf of O'Malley Transportation LLC and Lindsay Cheatham, the defendants in this case.
Rebecca Brown for Plaintiff, TNC Leasing, Inc., doing business as Team Funding Solutions.
Okay, let's proceed.
Well, Your Honor, basically, I started on this case, I believe it was March or April of last year. I inherited it from somebody else at her firm who had been on it for about a month or two at that point. And, I worked pretty hard to get up to speed with the clients. Certainly, I understood their position. They not necessarily sophisticated in the legal realm, right? Incredibly nice people. They didn't really understand what was going on. They had just gotten sued. So I spent a lot of time that was completely unbilled to them, that I was just trying to explain to them the process and what to expect and moving forward. Really, I did basically the exact same thing for the next 8 months without any progress. And the clients want us to take legal positions that we don't agree with. They want us to pursue factual positions that we don't agree with. And not just that we don't agree with, but we don't think that they're supported in law, right? I mean, the law says one thing, I advise them what the law says, and it's just completely disregarded. And beyond that, they just have not complied with the terms of our attorney-client agreement. There's a pretty substantial bill that is outstanding. I worked with them on it for months and months and months and told them, hey, I'll keep going as long as we have a plan. And then in December, they just unequivocally told me that they're not going to pay anything at all. And it definitely got to the point where I had advised them so many times that I would have to withdraw, and I didn't want to do it because this is the first case that I've ever moved to withdraw on, and I don't like being in this position. But it was certainly don't really have any other option at this point. And even after we filed the motion and sent them notice, haven't heard anything from them at all.
Did you put them on notice of this hearing?
Yes.
Let me just see. is there any, just while I'm looking at this, is there any objection to this withdrawal?
No, Your Honor. And I'm looking right now, Your Honor, on their certificate of service for the certified mail. It's showing on the USPS tracking. It was delivered December 24th to them.
Did you give them notice of this Zoom link so they could sign on, or?
I have to see what they sent. I believe, it wasn't even my assistant who did it that day, but I believe she said that was on the court's website.
Okay.
And I've also emailed them in the interim between when we sent notice of this and today saying, basically advising them what's going on, seeing if there's another way that we can try to resolve it. And I just haven't gotten any response.
And I
Rhonda,
can't, oh, sorry, Your Honor.
no, go ahead.
I can't tell from the court's website because when Miss Pinson sent this out, like I'm aware she sent it to multiple people because there's multiple cases, but it just says to me, so I'm not sure if she included them on that Zoom link, but it does reference.
She wouldn't have included them. She would have included just the attorney. We don't usually notify the clients because the attorney's usually representing them. So it's kind of up to them. Just so you know, in the future, Mr. Hamilton, one way to expedite this, there's 3 ways to withdraw. 1, if you have client consent that's signed off on. 2, if you have a hearing like this, but you can also do what's called the 10-day letter under the local rules, which is usually the most efficient and quick way to do this, because unless they file an objection, you don't need to have a hearing.
Okay.
Just in the future, you might want to look at that. That would have.
Yeah, thank you for letting me know. It's great to know.
All right, I'll go ahead and sign it, and then I guess if there's any issues, we'll let you know. Rhonda, make sure that he did include the new address and contact information for the plaintiff, so make sure the clerks know about that, okay? Or the defendant, I'm sorry, for the defendant. All right, anything else, guys?
No, Your Honor.
Not at this time, Your Honor.
You guys have a great rest of your day.
Okay,
You as
thank
well.
you. It's great to see you again, Judge.
Great to see you. Okay. Mr. Ginsburg, it looks like you're an hour and a half early to your hearing. I was going to shut off the Zoom for a little while. Are you there?
I hopefully am here, Judge. I don't know if you can see me.
I can.
Great. I know, and I'm looking, Alana, I'm going to butcher your name, and I'm sorry.
That's okay. Go by Ugi. It's easier.
Okay, Uji. Uji's on the other side, Judge. So we're actually all here if you want to take us out of order or just do whatever you want to do.
It's totally up to you guys. If both sides are here and you guys are ready to go, I'm ready, but it's up to y'all.
We're ready to go, Your Honor.
I'm ready, Judge. Sorry.
All right, so let's go on the record, Tony. DC 21-15295, Markeith Ward versus Valerie Urquhart. Counsel, make your appearances.
Jacob Ginsburg for Markeith Ward.
Ugalahi of Foboche for Valerie Urquhart.
Okay, so let's first off, you guys were notified this was going to be a remote hearing. I assume there's no objection. Is there an objection?
No objection, Your Honor.
No objection, Your Honor.
Yeah, the other issue is this was originally scheduled for 11. You guys signed on an hour and a half early. I'm okay with going forward as long as no one objects. Otherwise, we need to wait until 11.
No objection from plaintiff, Your Honor.
No objection to proceeding now, Your Honor.
Okay, let's go ahead and proceed.
Okay. Your Honor, the Uji filed a motion to challenge the jurisdiction of the court. So I think that's why everybody signed on early. I don't know how you want to handle it.
Yes, Your Honor, if I may, my client's motion for summary judgment was pending and was set for hearing today. That's actually why we're supposed to be here. I was retained on the 27th, which is just 3 days ago. And in reviewing the file, I discovered that there may be a problem with the court subject matter jurisdiction based on what the plaintiff is asking the court to do. And so I had to bring it to the court's attention. And so I filed that yesterday as soon as I noticed it. And so I thought it would be prudent to take care of that before wasting the court's time in entering rulings if the court doesn't have jurisdiction to rule on any of those motions. So I don't know if the court wants me to proceed or with the motion for motion to dismiss, or let the court know what we plan to do with the motion for summary judgment.
So it's your motion for summary judgment, right?
That's correct, Your Honor.
But you're asking, I mean, it seems to me so I assume you're questioning the jurisdiction because it's a copyright issue and there's certain copyright issues have exclusive jurisdiction in federal court. Is that kind of your concern?
No, actually, it's the other way around. It's a trademark issue.
Sorry, trademark issue, sorry.
It's a trademark issue, and it's a statutory limitation on what the courts can do once the trademark is registered. And so I was going to present to the court today 15 USC section 1121, which says the court can't make any orders limiting or allowing a party to alter the trademark. This entire case, it seems, is about the name Bad Girl Biker Click. That's the center of the face of the trademark. That's also the center of the face of the copyright and is also the business name. Now, if the court were to grant what plaintiff is asking, which is order my client to stop using Bad Girl Biker Click, that would constitute an alteration of the trademark Bad Girl Biker Click WMC, because the face of the trademark seal has the Bad Girl Biker Click on the front and the WMC on the side. Such an alteration would violate that statute, and the court's hands are tied with regard to this statute that says the court can't make any orders that alter the trademark or that.
Does it say any court or just state courts can't do it?
Actually, it says no state or other jurisdiction of the United States. So it might be open to the federal courts to do, but definitely not a state court.
So you, Mr. Ginsburg, you kind of asked the question at the beginning, which I think is a good question, is what should we do here?
Right.
I understand. I just want to make sure I understand the procedural posture we're in at the moment. Is that the defendants had filed the summary judgment, and then after filing the summary judgment, they retained counsel, and now counsel is saying that there may not be subject matter jurisdiction. Obviously, that wasn't set for today,
Right.
So I think you should have an opportunity to respond. I don't know that that's correct or not. That may be correct. I'm not saying it isn't. And so what makes sense to me is that we go ahead and just, if you want to reschedule your summary judgment hearing, you could also reschedule this motion challenging jurisdiction and have that set at a future date so that Mr. Ginsburg would have an opportunity to respond. That's what makes the most sense to me, but I'm open to suggestions.
Well, that's actually what our expectation was. I mean, I filed it last night. I really didn't expect that Mr. Ginsburg would have had a chance to investigate the motion by now. So yes, I did expect I would have to get a reset. More importantly, after I discussed the subject matter jurisdiction issue with my client, she had actually told me that she wanted me to withdraw the motion for summary judgment. And if you decide that you do have jurisdiction, subject matter jurisdiction, then we'll just proceed to trial. So that way we have just one more setting. That's correct.
Do you want to go ahead and set your challenge to subject matter jurisdiction now so that we can get it on the docket, or do you want to, or what do y'all want to do?
Now is perfect, Your Honor. I don't know what Mr. Ginsburg thinks.
I think that's fine. I just need, just so we're clear, I got it at 9 o'clock this morning. So I need, I've had it for about 40, basically skim the title of it. That's about where I am.
That's fine. Do you want to shoot for like February 27th or early March? What is your schedule like?
That would be perfect.
And let me just, because we have this new rule the Supreme Court just adopted last week, so we're having to kind of pivot, is if you're okay with doing it remotely, You have the right to object, and then I would have a hearing. I don't think there's going to be any live. There's not going to be any live testimony at this hearing, right?
No.
No,
I
Your
do not
Honor,
expect so.
definitely not.
So I'm going to notify you if you set this on a Monday. I'm going to set this remotely. You have the right to object to that if you want to. I don't know why you would, but if you want to, you can. There may be a reason. I'm not trying to dissuade you from doing that. And then what would happen is I'd set you on a Friday. So if you know you're going to object and you have a good reason, I'd suggest just setting it on a Friday. But if you're okay with being remote, then I would suggest we do it on a Monday.
Well, I would prefer to do it on a Monday, Judge, and have it by Zoom anyway, because I think it's more convenient for the court. And we don't have any live testimony, so there should be no inconvenience to anyone.
Mr. Ginsburg, what do you think?
I think that's whichever Mondays are fine, Fridays are fine. I'm open to anything.
But are you okay with remote?
I am, Your Honor.
Okay. All right. So so February 27th, March 6th. I know you have young kids, Mr. Ginsburg. I think you still have young kids.
No, I'm an empty nester now.
You're an empty nester, so you may not have the spring break issue. So
Correct.
March 13th or whatever date you guys want, we can set.
The only date that's bad for me, Judge, is March 6th. I can do February 27th or March 13th.
Do you have a preference?
Judge, February 27th, I have a trial. So March 13th works and March 6th work. So I think March 13th looks like it works for both sides.
Let's do March 13th.
What time?
Do you want to shoot for 10 o'clock?
That'd be great.
Good, Judge.
Rhonda, are you there?
Yes, Judge, I'm here.
So it's a little confusing, so I want to make sure it's clear what we're doing. On March, so we had today set a motion for summary judgment. We're not resetting that. She just filed a motion challenging jurisdiction. I don't know if it's even been accepted by the clerk's office. Let me double check that.
It has, Your Honor.
Yes, it has been. So it's a motion to dismiss that was filed today. I don't know if you can see it on the system. Go ahead and set that for hearing on March 13th at 10 o'clock.
Okay.
And it'll be remote.
Okay.
If you could put in the notation that the parties have waived, we have this new rule. So put it in the notes on the system that they've waived objection to remote hearing.
Got it.
All right, guys. I look forward to seeing you guys on March 13th. I think this is kind of an interesting issue. I had a huge issue involving copyrights on whether or not we had jurisdiction over that. And it was kind of much more complicated than you would assume. So I'm curious to see what this trademark issue. So, all right. Anything else, guys?
That's it. Thank you for taking us early, Judge.
Not
No
from me,
problem.
Judge.
We'll beat the winter storm.
All right. That's good. You guys be safe. Okay.
All right.
Thank
Thanks,
you,
Your Honor.
Judge.
Thank
All
you
right.
guys.
All right. Bye. Thank you.